Good afternoon. My name is David Laban. I'm the President and CEO at the Association of Prosecuting Attorneys. APA is a national nonprofit located in Washington, D.C., serving prosecutors as well as their law enforcement and community partners. Thank you for joining us on our webinar today. Today's webinar, Protecting Victims' Rights and the Victim Voice During COVID-19, will be presented by Professor Meg Garvin from the National Crime Victims Law Institute, or NCVLI. During this session, Professor Garvin will provide an overview of victims' rights laws, identify key moments of risk to those rights in light of COVID-19. Special attention will be paid to how to effectively work with crime victims in the face of the ever-increasing use of technology by the courts, and particularly how to protect the victim privacy during this time. During today's webinar, you will be able to submit questions for our speaker using the questions box on the GoToWebinar toolbox located at the right side of your screen. If you need additional assistance, please feel free to contact us directly at webinars@apainc.org. Meg Garvin has both a master's as well as a JD and is the executive director of the National Crime Victims Law Institute and a clinical professor of law at Lewis and Clark Law School. Professor Garvin is recognized as a leading expert on victims' rights. She has testified before Congress, state legislatures, the Judicial Proceedings Panel on Sex Assault in the military. In her expert capacity, she serves on the Defense Advisory Committee on Investigation, Prosecution, and Defense of Sexual Assault in the Armed Forces, and on the Victims Advisory Group of the United States Sentencing Commission. Previously, she served on the Victim Services Subcommittee of the Response Unit to Adult Sexual Assault Crime Panel of the United States Department of Defense, and as co-chair of the American Bar Association's Criminal Justice Section Victims Committee, co-chair of the Oregon Attorney General's Crime Victims' Rights Task Force, and as a member of the Legislative and Policy Committee of the Oregon Attorney General's Sexual Assault Task Force. Professor Garvin received the John W. Gillis Leadership Award from the National Parents of Murdered Children on August of 2015. Meg, I had the opportunity to receive the award just a few years before that. And then prior to joining NCVLI, Professor Garvin practiced law in Minneapolis, Minnesota, and clerked for the 8th Circuit Court of Appeals. She received her Bachelor's of Arts from the University of Puget Sound, her Master's in Communication Studies from the University of Iowa, and her JD from the University of Minnesota. Professor Garvin, thank you for presenting today, and I will now turn it over to you.
Thank you so much, David, and I'm really glad to be here. You never expect your bio to be shared that much, so you're like, oh gosh, but I appreciate it. And I love that you were honored with the John Gillis Award. Mr. Gillis, John is an amazing hero in the victims community, and it was a great privilege to receive it, and I understand you receiving it too. So we are together for just about an hour, 55 minutes at this point. I am going to work my darndest to make sure that there are a full 10 minutes at the end for Q&A, and perhaps even a little bit more than that. So please be ready to ask questions, but don't hesitate to ask them along the way. And if they're relevant along the way, the hosts are going to send them to me and I'll try to weave them in. But if not, we'll be getting to them at the end. That said, am I going to have answers? Right, this is an evolving landscape. What are we all doing during COVID? And so I am not committing to giving you answers during the Q and what is traditionally a Q&A. What I'm going to say is it is a Q&C, right? Questions and conversation. Because I think together we can identify some best practices, as well as things that we need to be looking for as we move forward with this real shift towards really in our courts and in our criminal justice processes. So before I jump into the handful of things that I wanted to share with you and really brainstorm with you about, even though it's a semi-one-way conversation initially, I want to give you a little bit of who am I beyond my bio, because I think the lens through which I see the world is important for you to understand, as it is with any presenter, right? It is always useful to know the biases that they are aware of And then, right, there's obviously some I'm not aware of. I'm going to share with you the biases I'm aware of because it frames how I see the issues. And one of those is really about the National Crime Victim Law Institute. Can you guys hear me now? Okay. My apologies. I am not quite sure what happened. There's work being done on my street, so that could have impacted my internet. Hopefully that won't happen again. Just a quick frame, I'll move through this quickly. The National Crime Victim Law Institute was founded by a former prosecutor who recognized the big job you all have, right? He self-identified, his name is Doug Balouf, former prosecutor, then became a professor, self-identified the big job that a prosecutor has, right? Because it's to do justice, it's to pay attention to community, it's to pay attention to defendants' rights, it's to pay attention to the survivors' rights, right? It's a big job. And he recognized that meant there was no one in the system whose only job was to pay attention to the victim and their rights. And so NCVLI was founded on the idea that a lawyer for a victim, not who takes over prosecution, not who actually does anything with an evidentiary burden, right? But instead who just is navigating with a victim under attorney-client privilege in the criminal case could be useful to the survivor's experience of justice. That's why NCVLI was founded. So I have a lens, right? I have a lens that says that victims with lawyers can navigate criminal justice effectively in a way that reduces their trauma, right? Which studies have shown, and which can aid the system because survivors who feel supported often hang with the system longer, right? They don't turn away from it. So this is NCVLI's website. I will not spend time on this, but you can learn more about us on that website, including all of the ways that we do our work. So what are we going to do in the time we have together? David identified these, so I'm just going to reiterate them. I'm going to do a brief overview of victims' rights so that you understand what I mean when I talk about those terms. I'm going to identify some key moments of risks and discuss responses to those risks to protect rights. And bullets 2 and 3 will happen together. So I'm going to give you a risk and a response, and we're going to go through 5 of those. So what the landscape, victims' rights. I want to pause on this transition slide again so you see my bias and so you see how I'm going to approach these. As a victims' rights lawyer, as someone who focuses on the rights of the victim and representation of the victim, this slide actually tells you everything you need to know about my approach, and that's where that there's an apostrophe. Victims' rights, if there is not an apostrophe on the victim, right? If it's victim rights or victims, plural rights with no apostrophe, then victim is a descriptor on rights. as opposed to the owner of the rights. So victim's rights with an apostrophe means that the survivor owns the right and he, she, or they gets to deploy it how they see fit. That is why a separate lawyer can matter sometimes. It does not mean that prosecutors don't carry the water 99.9% of the time on ensuring survivors have access to justice and protecting their rights. It means that a small percentage of the time, the survivor is going to do something with their rights that doesn't go in the direction of prosecution, perhaps, or it is side by side parallel for purposes of agency and autonomy with the prosecution. On this screen is a quick overview of where in the country are there victims' rights. The punchline, everywhere, right? Every single one of you operates in a jurisdiction, as you well know, where there are at least statutory rights, right? That's the yellow gold map. And most of us operate in jurisdictions where there are constitutional rights, right? And in the last few years, there's been a move towards more and more states constitutionalizing their rights and or shifting their existing constitutional rights to add an explicit standing provision such that there's essentially an apostrophe on the rights, right? That's fundamentally what the recent shift in constitutional amendments has been. It's been about adding an apostrophe that allows a victim to ask a court to enforce their rights. That at its core, that's what the whole shift in recent years has been about. So punchline is we all have these rights and they are all being implicated right now in COVID-19 in new and unique ways. So on your screen is the Federal Crime Victims' Rights Act, right? This is 18 U.S.C. 3771. It was passed in 2004 and federal courts have been operating under it since. Very, very common rights that are threads across our country, right? If you pull apart victims' rights a little bit and you kind of go down to the core of what they are, majority of victims' rights are due process rights. Notice, presence, opportunity to be heard, right? Those are fundamental due process rights. And you see them embedded in the Federal Crime Victims' Rights Act, but also in the state constitutional amendments and statutes. There's going to be notice about what's going on. There's going to be an opportunity to be present and an opportunity to be heard, right? Generally speaking, the opportunity to be heard is constrained by those other rights that exist, right? So you get to be heard when your right is at issue. Again, a due process notion. And then there are some substantive aspects of the rights, right? As opposed to just procedural, right? The substantive are privacy, restitution, protection, right? So you see a schema that reiterates itself or has echoes in the state versions as well. What's on your screen right now is the California Constitutional Amendment, which was passed in 2008, right? So the federal statutory provision was 2004. California did a version of Marsy's Law, which is very different than the Marsy's laws that have passed lately because it has a whole section on parole, very different than the ones that are more recent. But what's on your screen are not a focus on the parole, it's the big categories. These same rights echo across the country in most of the rights provisions that exist, right? Some procedural aspects, notice, presence, opportunity to be heard, and some substantive privacy and protection. So these have been embedded in our law federally since 2004. There's some iterations of them that predate that. The new constitutional amendments of states started to come into being in 2008. Oregon did one in 2008 as well. But really, they predate it way before that, right? Arizona, most states, California even had a restitution provision in its constitution since the 80s and 90s, right? So they've been in law for a very long time. Most of us have not had them operationalized in courtrooms that whole time. They've mostly been in systems. Let's make sure a survivor is notified, they get the right to be heard at sentencing, those kind of moments. What we're seeing now in COVID is that the shift in our court systems is challenging how do we afford the rights. And I'm going to give specific examples in a second, but I want to pause here and define trauma for a minute. Because what we are seeing when victims' rights aren't being afforded right now in new different ways, and that all of us are struggling to find ways to be effective on rights protections right now, is that the the amplification of trauma is happening for survivors, right? Understanding some key definitional components of trauma is important to understanding why all of us, prosecutors, victims advocates, victims attorneys, fighting for rights matters. The definition of trauma, if you look both at the DSM and if you look in practice, it can be broken down into the things on your screen. Extreme threat, terror, and/or horror, plus loss or perceived loss of control. Those two things together actually equal a traumatic event, right? And what we are seeing right now is our criminal justice system pivoting because of COVID, but it is creating, I'm going to go back one slide, increased loss or perceived loss of control for survivors because they were told you have these rights, right? Most of us started cases before COVID. Some cases are happening, we're initiating prosecutions now, but lots of the survivors with whom we worked, right? We started our cases before COVID. And we said, you have these rights, whether it's the California, the federal, a different state. We said, you have these rights. And now our system, our criminal justice system, as it pivots appropriately to be responsive to COVID, is saying, wait a second, we might not be affording the rights, which contributes to a loss of control, an increased loss of control. Judith Herman's book that came out decades ago is still relevant. Understanding her theories and her research around trauma and recovery, particularly as it relates to the justice system, is particularly poignant right now, right? That it can and does, as the evidence showed, cause trauma to survivors if they are having a diminished experience, right? Increased loss or perceived loss of control. So that's all background. Most of you know that. I'm going to guess all of you know it, but you hadn't heard my frame on it, which I think is useful to understanding now how I'm going to move through the COVID risks and responses. So the first piece of all of this is just to know that most of what I'm going to talk about, NCVLI has resources on its COVID-19 page. Everything that we have done in systems like letters to courts, some of our briefings during COVID, you can find on our COVID-19 resources page. In addition, in the downloads, there is a document that we are sharing with mostly with victim lawyers to say, here are some things to consider as courts open again on how to protect rights. It is written for a lawyer advocate audience, but as prosecutors, most of it's relevant to you also, both directly because you could use it, so you can download that resource, but also so you know what a victim advocate or a victim lawyer in your community might be thinking about victims' rights, so that you can proactively have conversations with them, right? So that when they ask you to activate the victim's right to confer with the prosecution, right, with the state, which is a constitutional or statutory right of victims in every jurisdiction in this country. See, they're labeled the right to confer, the right to consult. You might have a glimpse of what they might be coming to talk to you about COVID. So either you can use it yourself or you can use it to understand what a victim's attorney or advocate might be asking. Okay, so before I give you the first risk, we're gonna do a poll. So I'm going to have us go ahead and launch the poll right now and get you guys engaged in what you're seeing in the community. So I want to confirm that the poll has launched and that answers are coming in. Okay, and let's go ahead and close the poll. And I do not have access to exactly how many people answered on each question, but my guess is most of you answered that you had seen all of those things. And if the organizers can share with me a little bit in the chat what came through, that would be fantastic. The punchline of what we're seeing courts doing is that they are doing a whole lot of things around release. We have seen at the national level, we have seen defendants move for release from jail as well as prisons, but predominantly jail, based on leveraging the compassionate release statutes that already exist, but amplifying those or trying to enhance those based on COVID. We have seen courts and executive branches, right, up to the governor's level, issue orders that are encouraging folks to petition for release from jail due to the risks of COVID while detained. I want to be very clear on this. Absolutely see the increased risk for persons who are detained and are in close contact with each other to have an increased risk of COVID. Absolutely see that, right? I am not trying to diminish that when I talk about victims' rights. But the punchline is, in all of those laws that we just talked about, a fundamental premise is notice to the victim. Notice when important things are happening, as well as the right to protection, which then through due process means they have to have an opportunity to be heard if their safety is at risk. And safety can be at risk in numerous ways. What we have seen nationwide is a ball drop from courts, not from your offices, right? Because you all are getting kind of slammed with this stuff, but from courts, generally speaking, setting up systems that ensure accurate and timely notice to survivors of these moves for release. And accurate and timely notice right now has to mean more than it did before, because our survivors may or may not be able to participate in the same ways they used to. So on our website, in those resources, you'll see a whole lot that we've been doing to get courts to issue standing orders about what notice has to happen if a defendant is going to move for release due to the COVID situation, as well as more recently trying to get courts to hold defendants to their burden to show why they are at increased risk. A globalized statement of increased risk when any particular jail does not have increased numbers of COVID having been diagnosed should not be sufficient. In addition, right, the timing of release cannot only prioritize the defendant, it has to include prioritization of putting in place those release conditions that are important for a survivor and or opportunity to exercise a safety plan. So we've been advocating for those things, and I encourage you to use victims' rights to do that advocacy, because you'll have some opportunities. All right, we have our second poll ready to go. So I'm going to ask us to launch our second poll. And I can't see the polls right now. I think it's because of the way I'm sharing my screen. So we're going to have it open and for about 30 more seconds. And then when we close it, I will ask again for the organizers to share with me what comes in from it. So take another minute here to take this poll. Okay, and let's go ahead and close that. And then share the results with the audience as well as with me as best you can. The next issue we're really seeing are these issues that you just took the poll on, right? And so many of you are seeing what we're seeing nationally, right? That courts are moving to live streaming things. It is a fascinating move that is happening around the country to live stream or to make available court proceedings in new technology enhanced ways, right? So the poll results, hopefully you all got to see those, right? 72% have seen live stream, 82% have seen them adopt some sort of video conference platform, and 53%, only 53% have limited the number of people. Super interesting. So live stream was this very early COVID moment, I think, where many courts are starting to move away from it and understand the risk, but some courts, particularly in rural communities, are still contemplating like open live streams. In fact, we saw proceedings being done on YouTube, a live stream on YouTube, and then one that was a live Facebook, right? And interestingly enough, or horrifically enough, they were protective order proceedings, right? Live stream is hugely problematic. And I'm going to first talk about the problems, and then I'm going to engage in why is it not necessary, even though we all have open courts clauses, right? So federal and state law, we have victims' rights, right? Core in those rights are generally some aspects of privacy. Sometimes that's articulated as dignity. Sometimes it's expressly articulated as privacy. We have that in our victims' rights provisions. We also have the generalized federal privacy right. But our state and federal crime victims' rights acts, right, statutes, and constitutional provisions have privacy and protection embedded in them. We deploy those in regular court proceedings in many ways, from closing courtroom at times to pseudonym practice to restricting media access to testimonial accommodations, right? We have all of these things. And the explicit victims' rights provisions are complemented by confidentiality laws, privilege statutes, explicit pseudonym laws, release condition provisions that go over protection, right? We have all of these laws that often we go through motion in limine practice to control the courtroom before something happens, right? And we have courtrooms that not everyone in the world navigates into, right? And yet we have live stream happening where anybody can access the courtroom without even trying, right? Essentially, without even trying. It's like you decide, oh, I'm gonna go on Facebook, and there it is. Our open courts clauses in the country, and NCVLI on its website has one memo that we submitted to the Texas courts on this. People are going to say, or courts mostly are saying, yes, our open courts provision, right, requires us to make it generally available to the public. Dig into the history, or reach out to NCVLI so we can dig into the history of your open courts provision. It does not mean that everyone in the world gets access to our courts. The open courts provisions have always been interpreted to be able to be constrained, right? Limited access can and does happen. And so there are arguments based on victims' rights where you can limit access. And when it comes to technology-assisted hearings, whether it's live stream or just a Zoom, right? Controlling who has access is completely permissible under victims' rights analysis, even when aligned against state or federal open courts clauses. It just requires all of us being lawyers, and doing the legal research and putting forward some memos, because courts right now are trying to default to, they have a fear of reversal, right, based on some weighty constitutional right of open courts, but it is not, it has been historically been allowed to be limited, and in the current circumstance, it absolutely can be. So this is one we're seeing regularly. All right, let's do our third poll and launch that one, and we'll have it open for a minute. We'll do the same thing. We'll have it open for 30 seconds, then we will close it and then share the information. Just another probably 10 seconds here. Okay, let's go ahead and close that and share the results. Fantastic. 84% of you said yes, and 16% of you said no. So continuing on the line of technology assisted, right? It is fascinating, at least to me, to see all of the platforms out there being used, right? Courts are using all of these, right? They're using WebEx, GoToWebinar, YouTube, Zoom, Facebook. I didn't put Facebook on there. We're seeing all of them, and they all have benefits and risks, right? Some of the benefits, I do want to pause on the benefits. For years, right? For years, decades even, right? There has been a push to increase access to justice through allowing remote access to our courts. So having worked with survivors across the country, I have often advocated for testimonial accommodations that include remote testimony, right? Alternative means of activating one's right to be present. So you're going to hold a hearing, but my client or the survivor is now living 2 states away. Could we please just open a telephone line so they can be present by telephone? Can we please have video access so they can observe the court proceedings without traveling, which in fact, in many ways can be better for a defendant / the accused, because then I won't be adding it to my restitution claim, right? My travel costs, which in most jurisdictions, my travel costs to court could be wrapped into restitution. So for a very long time, we've been advocating for these things. But what has happened is now our courts are saying, my gosh, we have to do this, right? And they're just plowing ahead without factoring the digital divide, right? And the digital divide has always existed, right? It has existed when you factor what kind of telephones everyone has had for the last decades. When you factor who has access to which kind of technology, even when we were young. I mean, I come from an incredibly privileged background myself, and there were moments in my life where my family did not have access to some of the same technological benefits that others had, right? So we did not have a TV for a very long time. And even when we had a TV, we didn't have cable. Now, did that impede my access to justice? No, I'm not comparing the things, but it does mean that we have to start challenging ourselves to say, what do victims, as well as the accused, have access to? And is that in alignment with what the court is deploying? So a concrete example is that we have a number of survivors with whom we work, and my guess is you do also, who do not have internet, right? So let's say a court decides to go online, right? And the victim has the right to be notified, present, and heard, and the court notifies them, or your office, right, your victim assistance personnel, notify the victim, hey, there's this hearing and it's gonna be by Zoom. And the victim is like, I don't have internet, or what is Zoom, which many of us were asking just a few months ago, what the heck is this thing, right? Or what is GoToWebinar, right? I don't know, right? So the victim is like, wait a second. So yes, they got notice, but no, they can't be present and heard, right? Or what just happened in a court case that we were working on, the court said, you can come to the parking lot of the courthouse and access our Wi-Fi and sit in the parking lot and be heard. That's actually what a court just said to a survivor with whom we were working. And it's like, well, is that meaningful, right, presence? Is that a meaningful opportunity to be heard, right? Because due process, fundamental notions of due process require those things. It can't simply be this willy-nilly aspect, right? And so the digital divide is real, and it's negatively impacting access to justice because courts are deploying one technology without consideration of access. So our jobs, your job as a prosecutor, my job as a victim advocate, is to try to bridge the gap. What technology is the court trying to deploy because it thinks it's best? What technology does this victim in this case have access to? And how do we meet in the middle? Is it providing the victim increased access to services such that they can access it? Is it asking the court in this particular hearing to open a telephone line in addition, right, in order to make it, and then to pause appropriately, right? pause appropriately to ensure that the survivor actually can be heard, can hear themselves, all of those things, right? The digital divide is real and we need to be paying attention to it. And it is our job to advocate the middle ground, right? To meet in the middle whenever possible. Okay, our next poll on the next risk that I think we've seen. So we'll launch this poll. We'll take about 30 seconds to give everyone a chance to answer this. Okay, let's go ahead and close that poll and share the results. As a presenter, just so you know, right, I get to choose what I'm sharing with you in terms of the risks we've been seeing, but what I'm sharing with you are the ones we have seen in more than one jurisdiction across the country. Okay, that's why I chose these. So 58% of you said yes, 42% of you said no. It is something that we are starting to pay more and more attention to, right? Is getting ready for speedy trial arguments. And what I want to flag first is that both victims and defendants have a right to speedy disposition, right? The right we are more used to, right? The one we're more used to talking about is defendant's right, right? Embedded at the constitutional level and then also codified in state statutes and constitutions, defendants have a right to speedy resolution. In general practice, hopefully we all know that the federal one puts minimal constraints actually on our timing, that most of our timing on speedy trial runs based on our state laws. Of course, defendants have these. Of course, we need to be paying attention to it. I hope you all agree with that, right? That we do not want lingering cases. That said, we need to be proactively talking about where does COVID run against, right? Like making sure that our courts are not counting COVID against the state, or more importantly, against the victim, and paying attention to the victim's right to justice. And so when we're drafting, either getting ready for arguments where we're gonna have to litigate, or proactively drafting, because several jurisdictions have drafted laws and rules around where the time is gonna count against, that we are doing that thoughtfully with regard to the victim and leveraging victims' rights to dignity, fairness, due process, and fairness in those arguments, right? And I encourage us to include those in our arguments, because when it comes to a weighing of interests, right, which an appellate court is eventually going to have to do with all of these cases, because I believe this is going to show up in the appellate challenges that come later. If we have preserved that the victim's state constitutional rights to fairness, to dignity, to respect were part of the analysis, then when an appellate court is weighing, did defendant's state speedy trial right get violated, they're weighing that against a countervailing state constitutional right of the victim, right? So preserving that in policy and in, and in briefing is useful. And so I also wanted to flag that victims also, so the one side is we all need to be ready for the arguments by defendants. The flip side is victims also in many jurisdictions, not all of them by any stretch, have a statutory, and a few states have a constitutional right to speedy resolution of cases, which means victims can also be activating this right, and you can be activating this right on behalf of victims. So these are like, someone called it recently surfing the issues, right? We're surfing these issues. These are a handful of the things that we are seeing in the country. And the last thing I want to flag, while I give you a preview that we are about to open this up for questions in about 4 minutes, so we'll have 15 minutes for questions, is that along the way, what are some things that we can do? And so now I'm going to loop back to what David said I would include, which is some privacy aspects, right? So on our website, you'll see a handful of the arguments we've been making about these things. But in practice, what are some things that I hope you're all considering? One, if a court is going to have a technology-assisted hearing, has the court put in place restrictions on who's allowed into that space, what recordings are authorized of that, and proactively putting in place protective orders around that? Are they allowing for an off the record, so not a live moment, if it is going to be open to the public, sharing of the name of the victim if pseudonyms are appropriate, so that in a live technology assisted hearing, you're not saying your name live. Instead, off the record, you've agreed on what the pseudonym is, so that on the record of the live hearing, you're just using the pseudonym. Are you paying attention, if it's going to actually include videos, to is the court paying attention to what's in the background of videos? We just had a hearing where in the background of one of the witnesses' videos was the person against whom a protective order had run, walked through the background of the hearing. And of course, the victim became terrified right in the moment, because it was just enough. It was just enough to terrify the victim, and that was it. She did not want to participate anymore. So paying attention to all these little moments around privacy and safety, I believe that our courts are permanently going to be doing more with technology. And from an access to justice standpoint, that is a good thing. From a victim's rights standpoint, it can be a good thing if we all go back and do some fundamentals work again. What constitutes notice for purposes of technology-assisted hearings? Notice has to include an opportunity for the victim to be able to access the right technology, right? Because otherwise they can't participate. Privacy and safety things, we need to be paying attention to names, to access to recordings after the fact, to what's in the background if we're doing a video proceeding. Speedy disposition, we need to be paying attention to both defendants and victims. Right, all of those things have to be being paid attention to, and it's going to be a challenging situation moving forward. I think the biggest thing that I would ask of this group, differently than what I ask of, for instance, victims advocates, is that this group, that as you are having to pivot so rapidly to pay attention to what the courts want from you, that you push back on the courts and say that every single process that they put in place has to factor the victim's rights, including the apostrophe of the rights, which means that the courts have to hit the pause button sometimes and ask the victim what he, she, or they need in order to access justice. And you all have a unique position to be able to do that, more so than the victim can do themselves. So with that, we have 15 minutes for questions. I'm going to open it up and see if any have come in or are on their way in.
Thank you so much, Professor Garvin, for your excellent presentation. We do have the questions rolling in at this time. I did also just want to flag that you provided a handout for everybody, which is embedded into everybody's GoToWebinar dashboard for some additional information on these issues. But I know we are getting some questions in, so I will go ahead and get started with that. I know that NAAV was offering some legal aid. Don't know if that is still going on. Do you offer any free legal aid? And if so, is there an application that is available?
Great question. So my organization, the National Crime Victim Law Institute, we don't often do direct representation. What we do is assist others who are providing it. So we will provide free assistance to lawyers or prosecutors on how to craft motion practice and arguments around this. So if you are fighting one of these fights, but you don't have the capacity to draft a legal memo making an argument, we'll do that. Obviously, we give it to you as a memo. You have to convert it because you're the lawyer in the jurisdiction. You have to do with it because we can't simply ghostwrite for you, right? Rules of ethics. But we can arm you with tools. We can arm you as a prosecutor. We can arm victim lawyers. In addition, NCVLI has a grant from the Federal Office for Victims of Crime, which is part of the U.S. Department of Justice, to partner with 6 agencies around the country, and you can find information about those on our website. 6 agencies that explicitly do no-cost legal services on victims' rights in criminal. And then we have a separate grant that works with rural crime victims and provides no-cost legal services to them in 3 different jurisdictions, right? That's a small number of jurisdictions. But if you are prosecuting in one of those jurisdictions, then we can connect survivors in your community with no-cost lawyers. And that's on our website, which is ncvli.org. We also partner with pro bono lawyers across the country. So we can oftentimes try to secure a pro bono or low bono attorney to assist in these moments as well.
Wonderful. Thank you so much. We also have a question that has come in about privacy. If a victim testifies using technology, Zoom, etc., and system is hacked, what rights do victims have legally against courts and tech providers? Can they sue?
So I am not a civil tort lawyer, so this will be a partial answer and a commitment to try to get you guys someone who has more expertise on that. The first part, right, cause of action against the court, right, we're going to have immunity, right? I don't see many opportunities to get around that. I suppose if there was an intentional actor in the court system that allowed the hack or that participated in the hack, then there would be something. But of course, we have to pay attention to that. With regard to the technology companies, right now, the technology companies are putting out a lot of disclaimers about what the risks are. So in terms of those 2 potential litigation moments, I think those might be hard, but again, I'm not an expert tort lawyer, so we could find someone who could give probably a cleaner answer or a more aggressive answer that might get to a yes. That said, what we can do, I think, to create opportunities for protections for victims is get courts, assuming they're not the bad actor, right? Getting courts to issue protective orders up front that bar use of things, right? So protective order, just like we would over certain evidence, right? You issue a protective order, it's for party use only, and sometimes, right, we can't even share it with defendant. We can get courts to issue orders that say no one can record this proceeding. If the parties have access to recording, that recording cannot be shared for any purpose other than these proceedings, right? All of those same types of protections, if the court issues an order up front, assuming they have personal jurisdiction over whoever the order runs against, then we might have contempt of court proceedings that we could bring. So thinking proactively about, is there an order I could get in place to at least put in some level of protection for the victim for an opportunity for redress might be something to consider.
Wonderful. Thank you so much. We also have a question about, do you have any frameworks for prosecutors to respond to victims' needs that are actually alternatives to incarceration, things like needing financial support, etc.? Do you point prosecutors towards any community groups in their communities or discuss how they might establish relationships with community groups and organizations who might be able to support in this way?
Absolutely. Frameworks, I'm not sure I quite understand that initial part of the question, but punchline to what I'm gathering from the theme of the question is yes. So our approach to victims' rights, again, is the apostrophe. So what we start with is speaking with survivors about what do you want? What would help you heal? How do you see, when I sit with a survivor, my question to them is, what do you see for yourself a year from now? What do you see for the accused a year from now? And then 5 years. And so we do some work around, like, what do you hope for? And oftentimes, very often, what they hope for themselves is a lot of healing, as well as financial recovery. And so we talk about financial recovery that includes the civil system, the crime victim compensation, and then criminal restitution. What are all those options? And then there's the mental health healing. How can we access those things? When you ask them what they see for and what they hope for with regard to the person that harmed them, very often it doesn't include incarceration, right? I mean, every survivor has different needs. Sometimes it does include detention because they see utility in that. Other times it doesn't. So then we point them to, first we start with which justice system will serve what you hope for best, right? So if a survivor comes to me before they go to you all, to law enforcement or the state, then I'm pointing them to the justice system, which can include simply community justice, right? Like the idea of restorative justice, which justice system might move them towards what they hope for themselves and for the person who harmed them. If they've already accessed criminal justice, I'm still helping them point to those things. And so then with regard to with prosecutors, one of the things I encourage is open conversations with the survivor about what they hope for and why participation or non-participation. I hope none of you use the word cooperation. It's a very much perceived as a victim blaming vocabulary and a prioritization of criminal justice over anything else, but why their participation or non-participation will either get them or not get them certain outcomes. And then pointing them to where they can get other outcomes, right? There are in many communities restorative justice systems in place. Some of those, I'll be honest, are excellent, and some of those are not. They're not based on the original theory of restorative justice. And so every community needs to assess, are they victim-centered or are they not? And then, right, there's civil justice. There's so many opportunities, and again, the apostrophe drives it from my lens. And while you all have a different job and can't always embody the apostrophe of victims' rights and victims' needs, pausing to ask the question about the apostrophe, what do you need, what do you hope for, I think is a good practice.
Fabulous, thank you so much. We also have a question about victims of trauma, that even though they may have internet, they may not have the ability to navigate all of the rules or keep track of all of the hearings. So do you have any guidance for prosecutors to help with those aspects as well?
Oh, brilliant question. All the questions are good, right? That was a bad presenter moment where it seemed to value one question over another. I did not intend to do that. All good questions. This one is near and dear to me, though. I hope that all of us have taken and are routinely re-engaging in taking trainings on neurobiology of trauma that are taught by folks who deeply understand it, so that we understand that the brain, in the immediate moment of trauma and in the aftermath, particularly when triggered, cannot navigate in the way that the rest of us do, right? If this, then that, or anything from really the prefrontal cortex has challenges. So taking trainings, number one thing, keep doing it. Don't think because you've taken one that you're done, right? Continue to do it because they're always a good reminder. 2, talk with survivors and normalize that their brain, when they cannot keep track of things, that their brain is actually healthy. So I think a second step for all of us is to normalize that this is what happens when when we've experienced trauma. The brain goes into its defense cascade and is taking care of us, right? And sometimes that means we cannot process in the same way, and that is okay, and that is normal. So then step 3, really think about how can we assist. Let's make sure our victim witness personnel, right, our victim assistance personnel, both system-based and community-based, are wrapping around the survivor and helping navigate on their behalf when they need that assistance, right? Not co-opting their agency or authority or autonomy, but really walking with them and saying, what do you need? Do you need reminders? What kind of reminders? Are text reminders or telephone better? Right? Tell me what might work for your brain today, and not operate on the assumption that what they need today is what they need tomorrow. And then the fourth thing I would say is compelling courts to recognize this too. So if we have a survivor who's particularly experiencing traumatic impacts that are affecting, in the question, there was an example of a specific effect, can't keep track of dates, right? Or can't keep track of hearing dates. If we know that about our survivor, then we need to push back when a scheduling thing happens that is happening too fast. And we know that our survivor cannot process that quickly. So if a court is going to try to schedule something within 24 hours, like, oh, let's come back tomorrow and hold that part of this hearing, then we need to push back and say, for this survivor, that would not be adequate notice. So I'm going to ask for at least 48 hours, right? So we need to know those things about our survivors. We need to be trained. We need to talk with them. We need to wrap advocacy around them. And then we need to give pushback on courts to accommodate for those trauma impacts. Those would be at least my 4 things that I think right now.
Great, thank you so much. And I think this will be the last question and then we'll wrap up. Do you think that it is problematic when trying to work within our system to decide what type of justice they want?
Well, this is a stumper to have as the last question because I'm not sure I fully understand it. If I'm understanding the question, is it problematic for us who work in the system to understand what they, the survivor, might want? Is that how you're hearing that question?
I believe it's meaning if they change their minds, if the victims change their minds about what type of justice they want, and trying to work within our system. If a survivor changes.
So this is, so if a survivor changes their mind partway through, you know, this is a larger conversation, I think, and I hope you all are doing trainings on this. And I'd love to be a part of a future conversation on this, right? I am a big proponent of survivor agency and autonomy. And I've even published on this in the sexual assault realm, kind of pushing the envelope on how much control they can have. This is why I think victims' lawyers matter, because you all at times will see significant harm to community from a perpetrator. And your ethics and your job might say to you, regardless of victims wanting to participate, I, the state, believe that the community needs this prosecution to go forward. And that's your job description, right? And if that's your ethics and your job description and you have a legitimate basis for that, then that's the way we structure a system. Do I think in those moments you need to compel the victim's participation through material witness or anything else? Absolutely not. Honor their choice and know that you just have a harder case. And figure out where it's possible and where it is not possible to do evidence-based prosecution. Why a victim's rights lawyer matters is because I need to be able to advocate aggressively that the survivor will actually be hurt more by you moving forward at times than not. And that is an individual interest. That's the apostrophe. You have sometimes a social interest. So these things, can they come into conflict? Of course they can. And do we need to have conversations about creating opportunities for the system to have off-ramps that achieve both social redress and individual redress? Yes. Do we have enough of those off-ramps right now? In my opinion, we do not. But those off-ramps have to be crafted to factor social harm and individual harm. And that's the conversation that I see that we need to have moving forward.
Wonderful. And thank you once again, Professor Garvin, for your excellent presentation and for answering these questions today. And thank you to our webinar audience in attendance. All previous APA webinar materials and recordings are available at no cost on our APA membership website, and we will be notifying you via email when these materials become available and how you can access them through a temporary membership. If you are a current APA member, you will have automatic access to webinar materials when they are available online. And if you have any questions, please email us at webinars@apainc.org. Thank you all once again for attending and have a nice day.